Hi, I'm Jim Covington on behalf of the Illinois State Bar Association. Today is September 27th, and I'd like to welcome you to this week's issue of ISBA Statehouse Review. We're going to step outside of my comfort zone a little bit here because we don't have any new bills being introduced or new public acts being enacted. I thought I might spend a little time giving you a quick and short or quick and dirty overview of whether or not whether a bill is an act is effective. Its effective date is what is its application date. In other words, does it apply to pending cases or retroactive? This is clear as mud, but I'll try to give you a quick overview. My source for this is going to be the Legislative Reference Bureaus in the State House, their Illinois Bill Drafters Manual. They have an excellent manual up there, and we should have on your screen the 2 pages that are relevant here, from which I am gratefully borrowing and want to acknowledge that. In retroactivity, you all know what, when you see the bill and it's at the end of the public act, it'll say what's effective date. The question then becomes, is it retroactive or apply to pending cases? Retroactivity may be unconstitutional under one of 3 reasons. And the first 2 are both under the federal and state constitutions, and one is ex post facto law. Does it violate that? And then the second thing is, does it impair the obligation of contracts? The Illinois site is Article 1, Section 16 of the Illinois Constitution. The U.S. site is, the federal site is U.S. Article 1, Section 10 of the Constitution. The third reason why it may be declared unconstitutional by the courts is if it interferes with a person's right under the Due Process Clause of Article 1, Section 2 of the Illinois Constitution. That is under the umbrella of the Illinois Constitution only, is whether or not it affects the Due Process Clause. The courts have tried several different approaches on trying to give us a bright line approach. That has been, my loose recollection is that's just very difficult for the courts to do because it gets so fact specific. But the latest approach, a 2002 case, Cavaney versus Bauer, is the approach that we're now using, or the courts are using. Under the Cavaney approach, which I'm going to refer to it at, and the site should be on your screen, did the General Assembly clearly indicate the temporal reach of the legislation? In other words, what did they clearly intend for it to do in terms of whether it should apply to pending cases or retroactively or prospectively only? If there is a clear indication of what they want to do, then the courts must give that effect unless it's unconstitutional. And then the question then arises, well, how do you determine if it interferes with a person's due process rights under the Due Process Clause? And that the short answer to that is who knows. There is one case that has attempted to do that. It's a tax case, the Commonwealth Edison tax case, and the court in that case looked at some elements there, such as the legislative purpose behind the law, the length of time of the retroactivity, whether a person reasonably and detrimentally relied on the law as it existed before the change, and whether a person had adequate notice of the change. And that's the Commonwealth Edison case. If the court didn't clearly indicate the temporal reach of the new statute, then the Cavaney court says that you must default to Section 4 of the statute on statute, which the Supreme Court in that case has interpreted as barring retroactive application of a law if it has substantive changes. So that's when you get into the substantive or procedural, what kind of rights or change was it. And I suspect that will be as clear as mud in a fact-by-fact analysis. 2 points to remember, just to sort of add on, is a lot of times you'll see in a statute where it says this act is declaratory of existing law. I'm not sure whether that gives, and I see that occasionally when people are trying to be careful. That does not mean it will be enforced retroactively. Just saying it's a declarative existing law doesn't make it so, to make a long story short. And there's a case that on your materials on the screen, the Northern Kane educational case in 2009, that will give you more guidance on that. And the final point is, often you will see when a court has to declare an act unconstitutional, you will see a severability clause in there often that says if you declare one part of it unconstitutional, don't declare the other parts of it unconstitutional. If there's no if there's no severability clause in there, then the court has to make a decision whether to strike the whole thing down as it's so interrelated or not. So in terms of legislation, it's always important to look for the severability clause. I don't know if I was very clear today, but it is not a very clear subject and difficult to parse through, but I get these questions now. What does this apply to in terms of timing? And I thought I'd give you just a quick overview, and we'll see you next week. Thank you.